Good evening, and welcome to Land Title Talk, where we encourage you to call in. Well, I keep saying that. Bad habit. Where we encourage you to text in. We used to have a radio show for many years. Text in your questions or comments at 904-501-4481, 904-501-4481. You can also listen to us live on the 904 Now app, right?
Yes.
And there's several other platforms.
Our Land Title YouTube page.
Land Title YouTube page.
Land Title Facebook page.
Land Title Facebook page, okay.
And whatever else the 904 Now has.
Yeah, the 904 Now. So you can listen on several platforms. You can also email questions or concerns at Stephen, S-T-E-P-H-E-N, at golandtitle.com. And we'd love to address your questions here on this show. I'm happy to have Rusty here with me.
I'm here.
Rusty Collins from the law office of J. Russell Collins, affectionately known as Rusty Law. And then we have Ben Jacoby, Dr. Ben Jacoby. He also works with Rusty at the law office of J. Russell Collins. We appreciate you being here as our guest.
Glad to be here.
And when we have Julie here, always keeping us in line. Thank you, Julie. We appreciate that. She'll look up things when we try to go astray. She'll get us back on track. Rusty, what's going on in your world?
Not a thing.
Great, because I want to get back to what we talked about briefly. Last week, we were talking about mortgages.
Yes.
We talked about seller-held financing, whether or not you should use a broker, all those kind of things, what the risks are.
Sure.
What could deem you as a lender, and those kind of things.
Right.
We're clear that if you're not putting yourself out there as a lender, you might be in the clear. Doesn't matter how many loans you do.
Well, I mean, yeah. I think there comes a point where if you're doing 10 loans a month, something's up. Okay.
Okay, but if you're
doing a couple, 2 or 3, 4 a year,
and you're holding 10 loans, you're not going to be deemed a lender.
Not according to the statute that I have reviewed, and also the case law.
You're willing to defend?
Yeah, I'll defend anything.
Okay.
Pay me.
No, you're willing to stand on that?
I think so. Yes.
Don't see. I hate it when you say I think so. I need a definitive. I am sure about this.
Well, it's like this. I'm sure until I get a judge tells me otherwise.
Okay, that's not comfortable.
Okay, I don't care what the statute says. Some judge has to.
Because we've been preaching for how long, Rusty?
We've been preaching, but
how long have we been preaching that if you do more than 3 loans or 5 loans, we could argue about that number all day long. You're deemed a lender.
Well,
you follow the same rules and regulations as any.
The number 3 comes from the real estate agent's addendum about mortgage loans and about the CFPB and whether or not it's just like a safe harbor. If you've done less than 3 and it's purchased, you're not in the business of doing purchase money loans because you're not selling a whole subdivision. You know that. And
you did mention that last week about the whole subdivision thing. I mean, you could be in trouble if you were doing that.
I think
if you have a subdivision and you're holding seller-held financing on all those loans.
Right. So what are you doing when you do that? You're saying, hey, we go financing on these 500 lots.
Right.
Okay. Well, isn't that setting yourself out there as a lender?
Okay. That's respectful.
I think that's different than saying, hey, home for sale, seller financing. Okay. That's different.
But we have private investors out there that have money, that their business is not necessarily lending money. Their business is buying and selling, but they have money and they're willing to lend. Or surfing. So in that case, you're saying do as many as you want.
Correct. Just don't let it be known that you're a lender. You're lending to people that you know. That you're not going out there and say, hey, if you need a loan, call me.
All right. What if you do that?
I think you need to be very careful.
And what's that careful mean? If I'm out there, hey, I want to loan you money. Come to me.
I think if you have a friend that you know is doing real estate investing and say, hey, if you get in a bind and need financing for a short-term deal.
Or they have a friend that says, hey, I need money. Like, yeah, man, I know this guy does it. Go to him.
That might work. I think you just got to be careful, okay? The easy way to do it, I mean, we have our mortgage broker that we do a lot of business with, and there are people that they get to know their lender from the mortgage broker,
right,
private loan, and they'll go back to them.
Right.
And that's not cool, but and so when you have a mortgage broker involved, the mortgage broker is the acting in place of the lender to be the lender. Okay. And they're doing all the things that they have to do, and they have the number for it. That keeps the actual money person safe. Okay. When it comes to the rules, because it's the mortgage broker that's saying, hey, we loan money, or we set you up to, to borrow money. But, and then if that borrower goes right back directly to that lender without the broker, that might be a violation of their contract they have with the mortgage broker, but that does not make that person a lender.
Does not make them a lender.
Right.
Okay. I just want to be clear on this. I've been telling, as well as you,
I know,
that if you do more than XYZ amount of loans, you're a lender. And that's been false information.
that's correct. So,
Okay.
But you have to understand where it comes from. Certain types of actual real lenders that loan money, if they loan certain kinds of money in a certain way, then you have another set of rules that come in when it's a higher interest rate loan. Okay, there's some thresholds. That number 3 comes up a lot. So that's why you check.
I think the safe bet is just use a mortgage broker.
Here's the thing, the mortgage broker is not getting paid just to point to a lender and say, here, go get the money and give me a fee.
Right.
They do the qualification. They make sure that, and the broker has some duties. They're not allowed to do equity skimming. People have to actually qualify for the loan. Their debt to income ratio.
But if you are a lender.
Right. If you are a lender.
If I'm just loaning money, I don't care.
Right,
if equity's there, I don't care if you can pay it back or not.
Right. But the mortgage brokers have that duty.
They have that duty. And if you're a lender, you have that duty.
Right.
You have to prove that they can repay the debt. You can't just give a loan based on the fact there's $200,000 of equity.
Right, because we don't want people to just lose their homes.
Right.
It's kind of weird when they're in a bind and, well, we're going to lose the home to this problem, or we can do this other loan that we may or may not lose our home to.
That gives them breathing room, though. It gives them a chance.
Right, but that doesn't work.
Sometimes when you're facing death's door, you want to extend your life for a little bit longer, and that's what sometimes these lenders will do. Excuse me, investors.
Very careful.
I'm a lender. I know. I'm almost set myself up there. Is they want to give the people the time they need to be able to
but what happens
have another day.
But what if that doesn't work out?
Yeah, well, at least they had a chance, right?
Yeah.
You don't have a chance at all if you got foreclosure a month away. How much better is it for them to get an extension of that?
There are times when that makes sense, and sometimes it's better to back up, regroup, take the hit, and go.
I think there's too much ambiguity here for anybody to feel comfortable. They're out there loaning money,
right?
Because all of a sudden they're now deemed a lender because they liked it so much. It's easy. They're collecting payments. They're having good payers, and all of a sudden now people look at them as you're a lender, and so now they run the risk of all these rules.
Okay, so here's what you got to understand. I go around and around with the mortgage broker I do a lot of business with about compliance. Okay, and how do we figure out what the statutes mean sometimes? Where do we go to find that out?
Case study, case law.
Case law.
Right.
What does that mean?
What people have exercised and
it's when somebody got sued.
Right.
Or challenged, or they got charged with violating the law.
Right.
And then the loser said, I don't like this, and they go to an appellate court. That's how we figure out what it means. There's not a lot of case law on this. But now the case law that I am able to find on it is where a person makes a deal to get a fee, and then something happens, and then they didn't get paid, and they try to sue for the money, and then they lose, and then the appellate court says, well, you weren't a broker.
Okay.
So that's what happens.
That's been proven time and time again. But there's no ambiguities there.
Well, but the other concepts come up, but not real clear. The problem we have is there's a lot of things that have not been challenged yet, and who wants to be the first one?
All right. So give your final suggestion to a person who is finding themselves loaning money a lot.
I would use a broker.
Okay. Use a broker.
We've got Mortgage Market. They have a good reputation.
Mortgage Market has a great reputation.
And that reputation has been won over many years.
Mm-hmm.
They do their best to help lenders when something
Then
goes
you
bad.
don't have to worry, right?
That because Mortgage Market is the one that has to
Now,
be
if you're
compliant.
using Mortgage Market for your loans, but you have your friend come to you, I mean, you can sometimes work outside that umbrella of protection, for lack of a better word. If you
right,
have.
but you're not using your reputation as a lender.
It's
to
so
do that.
easy to turn into that, though. You may not be advertising it, but everybody perceives you as that,
Right,
and then
again,
you could be in trouble.
well, okay. These exemptions in the statute, the state or whoever or the financial department, they don't have to prove you don't have the exemption.
You do.
You have to prove that you do.
Guess
It's your
what?
burden.
Yeah, and that's expensive.
Right. So
It is expensive.
it's your burden to prove that you have the exemption. So I would be careful. Get counsel, and it doesn't. Using a mortgage broker to loan money for you, they have good opportunities. And they bring I think a good value to the real estate world to do what needs to be done. And there are times they really can't get a loan approved, or they have to do it a different way. But there are a lot of things they can do quicker, and they can't do like they used to do. Okay, I could call Jim Acelta and say, I got a piece of property. Here it is. Here's where this is what it's assessed valued at.
Mm-hmm.
I have a first mortgage position of this versus this value, and Jim would just say, loan approved. When do you want to close?
Right. There was equity. It was equity lending.
Right. But you can't really do that.
You can't do that now.
You have to be
If
very
you're deemed a
careful.
lender. If you're not deemed a lender, you can do equity lending all you want.
unless you get a reputation for it.
That's the problem. Okay. I think, and I appreciate you rehashing this. I don't think we really settled that because you really.
So I was going to ask you a question too.
It's hard to hedge.
Yes.
So what if someone wants to get a loan? They may not qualify through a traditional bank, but they really want to buy something. What should they do? And how can you guys help?
We give you the phone number for Mortgage Market.
And
There
that's
you go.
really what we would do, because we want to be careful and make sure that, all the T's and I's, the T's crossed, I's are dotted when it comes to financing, so that we don't we have lots of friends that are lenders, but I don't want to put them in a.
That are who?
Ooh, see, I just did it. You see? That's the reason right there, dude.
Well, but we're insiders.
And I can't get away from it.
We're insiders to that industry.
Well, we are insiders, but just look what I did.
Well, you're talking
Investors.
This is why.
They know lots of investors.
Yeah, but what did I just say?
Mm-hmm. That's right. So you have to be careful. And again,
Yeah, to be careful.
We don't
just
want you
use
to
a
be,
mortgage market,
Right.
a mortgage broker.
And here's the thing: if you want to get into doing that and collecting your mortgages, that's great. I would think you'd be better off to do that. And then if you have the odd friend that needs a loan, fine.
All right.
Do it.
All right, so we have a different scenario.
Okay.
Guy's in trouble, man. Foreclosure's knocking at his door. He's about to lose his house. He goes to his friend and said, "Listen, man, help me." And the guy says, and his friend says, "I will help you." And let me do it this way, because we can get confusing. Ben, do you mind if we use you and me?
Sure.
All right. I'm the guy in trouble. And I go to you, Ben, and I say, "Ben, I'm in trouble. I don't want to lose this home to foreclosure. Will you buy this house from me? And then I'll pay you rent with the opportunity for me to buy the house back in 5 years. And I will go ahead and sign a contract with you to pay you $20,000 more than what you're paying for the property." Now, mind you, I'm going to rent the property during those 2 years or 5 years, whatever it takes.
I wouldn't do it. Here's the thing. If you were going to do something of that nature, you would have to be extremely careful that you don't set yourself up to making the deed, the conveyance from you to him, as a deed to secure a debt.
That's really what it is.
Okay.
Well, maybe.
Is it not? Hi, Ben, buy the property from me. Let's say the foreclosure is a $300,000 foreclosure. Okay. I need $300,000. Whatever it takes to satisfy the foreclosure, that's what you're buying the house for. We'll set a rent that's pretty much within market or a little bit low because you like me. I'll pay rent for 2 years. And in 2 years, I have a contract that says I'm going to buy it back from you and we'll make the property a 20 or 30,000, whatever he's got to have.
Okay, what happens if he doesn't pay the rent for a month? Is it a rental agreement or is it a financing agreement?
That's a great question.
Because a rental agreement, I give you 3 days.
You still have a lease.
Right, you have a
He
lease.
still has a contract to purchase, though. I guess that contract to purchase, you can tie the two together, can you not?
You can. So you would have to, number one, you need to have an agreement that this conveyance is an absolute conveyance. Okay, I know we use that
We do use that
term on
terminology.
our deed in lieu of foreclosure,
Right.
but you want to make sure that this is an absolute conveyance. I have not said I promise to pay. Okay?
I have the option to buy for $330,000. Let's just use that
If
number.
you make it an option, then that means there's no real estate contract,
There
right?
has to be a real estate contract. For an option?
What's an option, Stephen?
It's a contract.
Is it?
Yes.
What is an option?
I have the option to purchase
Based
So-
upon what?
based on terms that we agreed to.
Okay.
That's a contract.
Okay. But what an option actually is I offer to sell you Blackacre for $100,000. You can accept it anytime between now and 2 years from now. Okay, and I will hold it open for you, and you can bind me to sell it to you for that much money. But you have got to give me something for my promise not to withdraw the offer to sell it to you.
Contract.
An option is a contract, but it's
Thank
not
you.
a real estate contract.
Thank you. It's a contract.
Okay, without consideration.
Did I say real estate contract?
You did.
Okay, well, that's fine.
Okay.
It's still a contract.
Okay, but you must have a way to bind that option, because I can.
Rusty,
if
you
I
have to
offer-
have consideration. I get
Okay,
that.
if I offer to sell you my property, until you say I accept the terms that I've given you,
Mm-hmm.
I can withdraw that at any time before
Correct.
you say I accept.
Correct.
So you have to give me something for a promise not to withdraw it for a specific period of time. Now, if you have an option to buy property, and again, my problem with this whole thing is it is rampant in Putnam County. Okay, I have way too many cases where there was some kind of a rent to own something option. Nobody knows what they're really doing, and it goes bad because now the landlord seller person, well, you didn't pay the rent. I'm giving you a 3-day notice, and we're filing an eviction complaint. Well, if somebody comes to see me, we're going to do a motion to dismiss and remove it to circuit court from county court, because it's really an ejectment action, and I haven't, and maybe it's a mortgage that you have to foreclose. Because if I'm
Right.
paying if the
And we
buyer's
had a
paying the
case like
taxes,
that. You actually had a
I've
client
had several.
where you had to foreclose an unrecorded agreement.
Right.
Yeah, which we're going to talk about agreement for deeds too. But
Just say no.
we're going to talk about that. But and I think this is the misconception that people have. People come to my office, or you've heard this before too. I don't want to have to foreclose.
I don't want to have to pay taxes. We're going to both be disappointed.
So that's the misconception. This is why people do rent to own or agreement for deeds.
Well, but again,
Or
agreement
you
for deed
rent
have
the
to
property from me,
Mhm.
and then in 5 years, we have a contract. I've actually seen this, Rusty. There's a contract with a 3-year closing date with a rental agreement.
be okay. And I've written those where
Yes,
you
you
have
have.
a real estate contract that's fully executed.
Yes.
Okay. However, it is subject to the person completing this lease agreement,
Yes.
and no part of this rent is going towards that purchase price.
that's where but see, that's where they get caught up.
If you're
They always sit there and say that I'm going to take the rent money, which is by the time you take and divide it up is what they're doing. A portion of it's going to it's an amortized loan.
What's the okay?
It's an amortized loan.
The
They
other
actually
question,
amortize this, and they're putting the principal
Right.
on the amortization towards the principal.
right? And I don't care what your deal is. Who's paying the real estate taxes? Who's supposed to pay it?
Well, the owner is supposed to pay the real estate taxes, but they're not.
If it's a rental agreement, yeah. So,
But that's not what they're doing. They're actually it is a rent with purchase contract, and they're applying. There actually is an amortization schedule attached.
right. I have a case.
So in that case, we have,
a contract for deed or an agreement for deed or
and
financing.
if the buyer wanted to be a real stink pot about it because the guy's trying to evict him for not paying his rent,
they're going to be in circuit court and it's going to be determined to be a mortgage.
it's going to be a foreclosure.
You have to foreclose.
So that doesn't get you out of a foreclosure.
No.
Okay.
Well, here's the thing. But if the person that's buying, renting, whatever, is not sophisticated enough to call me,
That's true.
Okay.
You get away with it, but that's
well, right, because the landlord thinks they have their own little fiefdom going on, and they
what
think
was
it's
that word?
fiefdom. I don't know. It's yeah,
Is that,
fiefdom.
are you going to send me this word?
Yeah.
Yeah,
Fiefdom.
Think little castles and
Yeah.
serfs running around.
they think they're the lord
you
of the
gotta talk louder
manor.
than that.
I'm
Okay,
sorry. Castles and little serfs running around and Monty Python.
okay. This
This
happens.
is a Mighty Python thing. Okay, landlord has their
Fiefdom.
fiefdom.
Okay, they think
Great.
they're king of the manor,
Okay.
and you're just a little peon.
Mm-hmm.
And you pay me or I kick you out.
Okay.
Okay. And maybe if you pay me every month, I'll give you a deed. Maybe not. We'll see. I might die. All right. So, but here's the thing.
So we've talked about. I mean, the risk of or getting over the having to foreclose these agreement for deeds and these rent to owns don't do that at all, really, unless you
If you can
get
fake
away.
if you can
fake
fake it,
your way through it.
Yeah.
The
if
thing
it goes to court, I can tell you this: if it goes to court,
you're gonna win.
the person buying will win. Now they're going to have to maybe pay off the deal. Okay.
Yeah,
Depending on what
I
the
get
terms
that.
are.
I get it, but they're not getting kicked out.
Well, let's just put it this
Without a
way.
foreclosure.
There was a commercial case in Putnam County. My client was trying to do an eviction. His attorney, who I know quite well, had no idea what he was doing when he went to trial.
Okay, that
And-
should be your favorite.
Huh? No, I wasn't there.
Oh,
I got
sorry.
in-
You
I-
missed out.
I got in it after all this nastiness happened. They proved, the defendant in this case proved an unwritten agreement for deed.
Okay,
Okay?
how?
The facts that were agreed to was paying monthly. He was paying the taxes, or supposed to pay that. He didn't pay the taxes. He was
Wait,
supposed
I think
to
I
pay.
know this deal.
You might,
Yeah, I do know this deal actually.
but it's in Putnam County, and right now we're arguing
going on
about
for
how much the
years.
payoff is. Oh yeah, but what's the payoff? Is there an interest rate? How would we have an agreement for deed without an interest rate? They didn't pay their taxes, so we want we want to get that money back. You know, all these things, and they didn't pay every month like they should. So shouldn't there be a default interest rate or something? Maybe they don't pay interest while they're paying their payments, but when they're not paying and they skip a year and a half, shouldn't we get an interest rate then?
Wow.
So this is why you don't. And again, I don't necessarily agree how the judge did it, but I know that the problem is, and it's my client's own fault for doing a deal like that.
Right.
Because why do you want? He had to pay thousands and thousands of dollars to lose at trial. Okay, he could have just paid a little bit of money and had a lawyer do it, and they would have had a deal that he could foreclose.
Right.
Okay, because the issue that
The shortcuts just don't pay.
well, here's why.
I mean, they're trying to go around dock stamps and intangible tax too. Is the other reason why they do that.
Well, you know, Uncle Ron needs his vig. Okay, he wants his tax. I don't blame him. But the problem is the concept of the equity of redemption. And what is that?
Well, that's someone's right under the law to redeem, to protect their assets.
Right.
You know, they should have a right to remedy the issue.
Right. So, what am I when I go and redeem a property from foreclosure? What am I doing?
You're taking the judgment, and you're either making whole on the obligation.
Right. So but that right exists all the way until the clerk files a certificate of sale after an auction.
It's a certificate of sale.
Not a certificate of title, certificate of sale, which happens after the
title
auction.
is 10 days.
Right. So typically, now back in the good old days when we had live auctions, because a lot of the investors I knew, they had instant money. They had cashier's checks for their 5% that they would use every time, and they would just recycle them, and then they get it back. So they would go from the auction to the bank and come back, and pay, and then that certificate of sale would be entered
and not redeemable at that moment.
Unless nothing.
Bankruptcy.
Not if they file bankruptcy after
The certificate of sale.
certificate of sale.
Okay.
Okay. You have the absolute right to redeem until a certificate of sale. And you don't even need a payoff letter if you don't want one, because you can.
The judgment is the payoff letter.
The judgment is the payoff letter for the day of the judgment.
Right.
And there will be some other fees.
Right.
But typically the attorney's fees have already been built in recently, and I've done this more than once. In fact, I enjoy doing it.
More than once.
Yeah.
More than less than 100 times, maybe.
Yeah, less than 100 times.
Barely.
Where the judgments for a certain number that they prove to the judge, but you don't have to prove anything on a payoff letter, do you?
I wish that were true. How many times have I sent a payoff check using a payoff letter, and then I get the freaking check back because something changed from the date the payoff letter was written to me, even though it was within their acceptance period? They still have a little provision at the bottom of that stupid payoff letter that we can freaking change our mind if we want to.
Yeah, it's not an estoppel letter. It is this is what we think the payoff
This is what we think it is, and if we change our mind, sucks to be you.
Right. So
I like judgments better because that don't happen.
Well, right, and you can, especially if the judgment happened a month and a half ago, and we haven't had 5 bankruptcies in between, and COVID and anything else that would stop the sale. If I don't want people
to have judgments, but I'm just saying it's just much easier.
They allow us. I can come up to a reasonable number that's buffered a little bit high to pay that off, and it is always less than the payoff letter.
So weird.
Because the attorney's fees are limited
on a judgment.
It's like this. I had a 9.
Well, nothing. That's what it is. It's limited on a judgment.
And my favorite part of that whole process is when you have a $9,000 mortgage, and they get to the summary judgment, and their proposed judgment shows about $4,500 in attorney's fees, because that's what they charge as a flat rate. And I'm there and said, Judge, we don't contest the foreclosure judgment, but we'd like you to keep it to the statutory rate of 3%. And Judge Ness says, that sounds about right. And it goes from $4,500 to $270.
That'd be an upsetting day for an attorney.
If I could, they still got paid.
I get it.
But
not from the borrower, though.
Yeah, but remember the trial we went to. Judge Maltz didn't want to really hear from us, but they had $4,500 in attorney's fees. And that was higher than 3%. So he gave them a different number.
Right.
But on their payoff letter that you had, it was a whole lot more money.
A whole bunch of more money, dude.
Right. So,
wasn't it like?
It was like it's like $220-some thousand, like almost $230,000. But the judge gave him a judgment for $200,300.
Right.
And the best part, of course, was Judge, they have that money on deposit. And Judge Maltz, who you don't want to mess with unnecessarily, said, "Why are we here?"
Yeah.
So
what's going on here?
But we, and it took them a while for this. We took them a few minutes to get the judgment, and then it took them time they had to send the money back to us. But the day or two after they sent the money to us, we got the money
Rusty,
ran through.
The point is, they're taking these shortcuts.
Will hurt you.
Yes. And then that doesn't even factor in the risk a potential buyer makes or takes.
Well, yeah.
Because now let's hit agreement. Well, let's stick with the contract for deed.
Well, here's the thing. I've got one for a house in Palatka on Hudson Avenue, which is almost completely. It's almost the same address we had on Sherman Avenue. Okay, so it's, I mean, it's just a perpendicular line away, and
if you didn't get that, we used to live in Palatka. Yes, we did.
Yeah, and the so-called seller landlord filed an eviction case.
Okay.
Now, I had worked with the father of this buyer renter person in 2013 or something, and I helped them out, and they came to me on this thing, and there was a rent to own kind of deal, except they didn't have a copy of the document, but they had a
what?
It was a rent to own,
and they didn't have a copy of it.
Couldn't find it,
well,
but they had an amendment to it.
Okay, did they have the amendment?
Yeah.
Did the amendment state all the original terms of the original contract?
No, but here's the thing, though.
Freaking dangerous.
Right, but so they filed the eviction. I did a answer that's, and with evictions, you got to file your answer, your motion to dismiss, and anything else all at the same time.
Okay.
And we also put all the money they said that was not paid in the registry of the court, but they wouldn't take that from us. You see, they tried to fix this, and
they just wanted them out of the house.
They just want them out of the house,
right?
And so
with no right to redeem,
right? So, with the landlord, it was funny. It was like a $98,000 deal, and it was $800 a month, and there was no interest, and it came out to 100 and some payments. Okay.
And
they put $10,000 down.
Wow.
And they'd paid for half that loan, or half that period that was going to go.
Yeah.
And but they're threatening criminal charges of some kind, which is made up. But it says, hey, they can have it for $50,000. I got a text message. They want to pay me $50,000. They can have it. Well, that's about what the balance is. I think he messed himself up, because that right there.
Well, that worked to the benefit of the buyer.
That acknowledges some kind of a financing deal.
My point is, Rusty, the risk that a potential buyer takes, or a buyer takes, is ridiculous when you do an agreement for deed, a rent to own, or any of these kind of agreements, because you're truly subject to the seller's life.
Yes. Well, it's
mean,
like this.
What happens? You go on an agreement. So, and I have a question for you, dear Rusty, my brother. I have an agreement for deed, 20-year financing. Okay. And before I can get to the end of that agreement for deed, the seller gets an IRS lien.
Well, if you have an agreement for deed, remember we have
you can't tell me that agreement for deed is going to be senior to that IRS lien filed against the seller. You can't tell me that it is.
I think you have a way to get that done.
I do not believe so.
What establishes priority?
The notice of the agreement for deed, but is not a deed mortgage. There's a reason why you have a deed mortgage. You have a deed mortgage, property conveys.
Right.
A property is no longer owned by the seller.
Right, but the IRS doesn't record for priority. Their decision to record is not based upon where they think other things are. They record to give everybody else in the world notice that they're there, right?
Yeah.
Okay. So if I have an agreement for deed that starts, if I have a contract that is
Rusty, I believe the IRS has every right.
I think they're going to fight
to seize that property.
They could
not evict the person. Okay, the person still, I think, has rights under the agreement for deed, but they have every right to seize the property and assume that seller's position.
That'd be fine, but they don't want to do that.
They don't, but they could.
Correct.
Depends on how pissed off they are.
Well, so
we've seen the IRS get pissed off at people and act in outrageous ways.
Yeah, of course.
And then that person now who may be trying to sell the property,
it's
do whatever,
really simple.
pay off the debt. What kind of problems are they going to have? If you have a deed
mortgage,
mortgage,
you're going to clean it up and you're going to do stuff,
and it's expensive. You have a deed mortgage. If the lender gets an IRS lien against them, it doesn't matter.
Right. They might seize the mortgage and sell it to somebody. Right. And the other thing with an agreement for deed is what happens if the seller dies. I mean, you have a place here.
You do,
but you still
have,
got to
it's
go.
just expensive to defend it.
Well, you still have to get a deed from somebody. If you got a mortgage, hey, if there's no maturity date on the mortgage,
It's 20 years.
20 years. It's
5 years
over.
after.
No, 20 years.
Okay, listen to me. Title insurance guy, lawyer. Title insurance people,
5 years after maturity.
after 25 years.
No.
20 years it goes bye-bye. 5 years after that 20 years it becomes insurable.
Well, that sounds like an underwriting problem.
That's the
Because
truth.
the statute says it's no longer a lien 20 years after the mortgage is executed unless there's a maturity date.
Well, you and I are going to have a talk later because I hope you're right.
I know I think
know what you
25
say.
years is 5 years after the 20, but that's not the deal.
But if you have a 20-year mortgage and it's recorded and it says
No,
clearly that it's a 20-year
okay,
mortgage,
if it says it's 20-year mortgage,
done after 20 years,
that's fine.
It's 5 years after that.
I agree with you 100%.
Okay, but so
If you have a mortgage that doesn't have a maturity date on it,
it's just 20 years.
it's just 20 years.
Man, I hope you're right.
You want to clean my car?
On that one, I would.
Okay.
I'd pay somebody to clean my car if you're right on that one.
Oh, it's no
Excuse me,
fun
did I
if
say
you pay
right?
somebody.
I would pay somebody to clean my car is what I just said. Shake on it. Just kidding. Yeah, take that back,
Take that back right
please.
now.
I'm not cleaning anybody's car.
No, but I mean that'd be great, Rusty. I don't want you looking up now.
I just tell you, it's really simple.
I've got to go to my title underwriters and present that to them, okay? Because what's legal and what's insurable are two different things, right?
Oh, always.
Always. So I like it.
The
I hope you're
difference
right.
between being alive and trying to get life
I
insurance
would
and being
clean
insurable.
your car just because I'm happy that you told me.
Okay.
Okay,
And
because I've screwed up on this already. If you're right, I've already screwed up on this where I've had a mortgage that was 20, not stated on the mortgage, 20 years have passed, but I didn't have that 5 years after the statute. My understanding of the statute. So
The lien of a mortgage
that's you don't listen. You don't have to go there.
shall terminate
He's going there anyhow.
after the expiration of the following periods of time. If the maturity date is shown on the mortgage or it's ascertainable from the record of it 5 years after the date of maturity.
Okay.
If the final maturity of the obligation secured by the mortgage is not ascertainable from the record of it 20 years after the date of the mortgage, unless they re-record it. Now, they could re-record it and extend it. Okay, but it's 20 years. Yeah.
Okay, that's interesting.
It's kind of like a
Okay,
it's
that's
kinda like
judgment.
marketable record title for that. Okay.
Right. Okay.
So, but
Hey,
hey, it's kind of neat though, huh?
yeah, I'm going to call my
Again,
truck cleaning guy to come.
We
clean your
have
car.
a lot of stuff, and again, an underwriter may look at it differently. They don't want to hire somebody.
I get it.
And we have a lot of-
but if the
we have
statute,
faith promoting rumors in the title world.
we do, but the statute's clear. The statute's clear. And I do
think
believe,
it's clear.
yeah. So that'd be interesting to figure that out for sure. Because if that's insurable, man, that'd be freaking amazing. All right. So I think what I'm trying to drive home is don't take shortcuts. A deed mortgage, cleaner.
Oh gosh, yes.
And
So the mortgage goes away, and you can get a satisfaction from
it's
somebody.
cleaner. It's safer for everyone involved.
Yeah, but you got all those
to
costs.
not want to foreclose is not the reason to take these shortcuts.
To not
Okay.
want to foreclose, you shouldn't be making a loan. If that is your biggest worry, why are you? Then you're not being
But
honest in
Rusty,
your loaning.
foreclosures are scary.
They
because
cost too much and take too long. Okay,
When you're
It's
trying
litigation.
to foreclose somebody out, they could file bankruptcy, Chapter 7, Chapter 30, whatever.
right.
Okay,
Because of
that
equity of
delays.
redemption.
Right, that delays it, and you need your money, and now you can't seem to get it. You've defended some.
I've
people being
defended
foreclosed.
mortgage. I've defended them for over 5 years. Won at trial, then had to do it again.
Yeah, so I mean, you can understand why some people are nervous,
Then don't do the loan.
but you can't live like that, Rusty. Foreclosure is a scary thing. If the paperwork is done right, what are the defenses? For example, let's go back to Ben and I. If Ben loans me money and he has a mortgage, and this is the only mortgage out there that he has,
Mhm.
and I don't pay, and he hires you to foreclose, how quickly could you get that done? If I decide not to be fight it.
Well, first thing, if I'm not worried about a deficiency, I will do the complaint and try to get an order to show cause as to why judgment should not be entered.
Okay.
Okay. Now, the nice thing about that is if the property is not owner occupied.
No, I want owner occupied on this example.
All right. So owner occupied.
Owner occupied.
All right. So
and
I can still.
You're doing the foreclosure for Ben. I'm not going to fight it though.
Okay. Well, if you're not going to fight it, I'm going to file the case and I'm going to get you to sign a confession.
I don't want to sign anything. I'm going to give you the middle finger.
Okay. Well,
I'm not going to fight it, but I ain't going to comply.
I'd still make a deal with you if you'd make one.
Fine. I'm just not going to show up, and you can default.
That's perfectly fine. If you don't show up, I get a default, go after a default judgment. It's going to take
how long?
At least 90 days to get to the judgment in this marketplace, probably. Or in this,
90 days, okay.
About 90 days, and then you're going to have the foreclosure sale. If you want to push it, they can push it to, 30 days.
So 120 days.
Basically.
All right. And that's if nobody's fighting.
That is
if I decide to fight it, meaning I'm going to argue that he's a lender, even though he's not. Or I'm going to...
Yeah, but see, you don't have the right to
I get an attorney,
but
I go to the attorney.
Florida does that, not you.
I go to the attorney. My attorney's going to argue that he's a lender. He didn't give me all the disclosures. He really didn't give me my 3-day right to rescind. It was a refund.
Wait a minute, but if he gave you the form...
I'm just telling you, if...
Those are all things that are easily
How long
remedied.
can he drag you out to where you're trying to fight this foreclosure?
If you have to get a hearing,
mm-hmm.
Getting a hearing is not, it's a luck of the draw kind of a thing.
Right.
Because I can go to Judge Janesk's, assuming Judge Janesk is the judge for that case, I can see when he has a hearing. And then I got to say, okay, the next hearing as available right now is, right before Thanksgiving, okay, that I could schedule. And they don't really want to they have these case management conferences, and sometimes you can weasel something in there, but sometimes you can't. So
Christmas has got to be a horrible time for you to try to get a hearing.
Oh yeah, because the court's closed. They got people doing into your stuff, and so it's not. It can just the scheduling becomes problematic at times.
So it could be how long?
It can take longer. Again, it depends on the uniqueness of what's going on, how bad you're fighting.
All right.
But here's the thing: if I have a lawyer contesting something and they're being stupid, okay, right, meaning they're raising things that they know they should know better on, then I have a remedy, and I can make the lawyer entitled to pay me some attorney's fees personally. Okay, there's a mechanism for that because we don't want people doing stupid stuff just to delay things.
Give me a time frame, if you had to guess.
6 months.
6 months,
maybe longer.
Okay.
Now I can tell you,
that's if they don't file bankruptcy,
right? So
6 months so you got 6 months if they don't file bankruptcy, and then after that it could be longer if they decide to file bankruptcy and mess with you a little bit.
So right now, I mean, looking at like Judge Janesk's calendar, you could have a hearing in October 6th. But then after that, it's November 6th.
Okay.
So and then it's, well, he has they're changing his
using the same scenario with Ben being the lender and I'm the borrower here. What can he do to protect his asset? Okay, well, not his asset. How about his, what do you call it? His assets. I mean, my house is the collateral. Okay.
How much equity do I have to mess with?
I don't know. Let's say we got $100,000 equity.
Okay. Well, so
it's worth $400,000 fixed up. It's $300,000 what I owe plus late fees. Because in a foreclosure, any money that Ben spends hiring you is going to be reimbursed to him.
If he can approve all the attorney's fees and the judge deems that reasonable.
Okay.
But they're a contractual thing. Well, 3% is a good number unless it's a $400,000 or $300,000 loan. It might not be that the judge is going to grant a $9,000 attorney fee.
Okay.
For it. Okay, I had one like that.
$5,500.
Well, it's like this. I had one like that where the 3% was 12 grand, and Judge Maltz put a line right through that number.
but if this borrower is dragging this thing out, for heaven's sakes,
Right.
okay,
So, and also, is there an HOA involved?
let's leave that out for now.
If there's an HOA involved and you're not paying the HOA,
Let's leave
that
it out
will
for now.
speed lots of things up.
Let's just leave that out for now for the equation. How does it protect this asset? I
But he's
start
getting
tearing up the place.
it's your place.
I can do whatever I want.
Yeah.
Okay. I start pulling toilets out, and I start selling off equipment. I start selling not equipment, but I start tearing the wires out of the walls to sell the copper.
Start selling used lumber.
I mean,
Used shingles.
what do you do? Can he do anything? Can he file an injunction to stop that?
Not that I know of.
Okay, that is the risk.
That's the risk you take.
You're right.
That's the risk.
Okay.
And I just want to point that out. So this
what
is,
good is it to you if you're tearing it
but
apart?
a person who does an agreement for deed or a contract for deed isn't going to get away from that. Is not going to get around that by
Well,
taking those shortcuts.
They might get around the, hey, you're tearing up my house. They might
Okay.
be able, okay.
Okay.
That's going to be very fact intensive.
Okay.
Okay. Because they might convince a deputy that that's my house
That's
and you're
my
tearing
house.
it up.
Yeah, okay.
And that's not what we
Whereas in a
agreed to.
foreclosure, you're not going to be able to prove or do that because it is their house.
Oh, yeah.
Okay.
So, yeah, there's risk involved in almost everything we do.
I get it. We just
You
try to
can
minimize the
mitigate
risk.
as much
Yeah.
as you can. I've dealt with one recently where there was a fire of some sort, and the borrower somehow convinced the insurance company to reissue the
gosh.
check.
Just in his name.
And
I mean, that's a
yeah,
whole
but
other
he's-
topic,
but
dude.
he's been charged with a crime.
Well, duh, it is a crime.
Yeah, and but then there was another fire right before the foreclosure sale too. So-
Same guy?
Same guy.
Yeah, that happened by accident. I'm pretty sure there been.
Well, but that lender is protected on it.
Bad timing.
Okay, so
That's-
but you better make sure the insurance doesn't lapse.
well, that's a problem because if it does, you're not getting first place insurance.
Not as an individual.
No, it's crazy, man.
I knew somebody who actually did it.
I've never seen it happen.
I don't remember who it was, and I don't know how
tried
to
to do it in a panic. All you can do if the person doesn't pay their insurance is foreclose.
Yeah, but you can also make sure that the insurance company,
Well, how'd you list it as lost payee?
and then if they're going to cancel it because it wasn't,
They
they
have to
weren't
give you
paid, they give you notice, and you
Right,
get
and
a
then you
chance
can
to
pay
fix it.
Right.
But it needs a new roof, and we're not going to renew unless you put a new roof on.
Yeah, and then you as the lender's going to have to put the new roof on. But what if the borrower's like, get off my roof?
Well, that's
I mean, it can become problematic. All right, there's risk. One of the things that we've seen this so much, and it's not funny. I don't even know why I'm giggling. It's absolutely horrible. Where a lender says, I don't mind loaning you money, but you're going to set a quick claim deed at closing. I'm going to put that in my drawer. You stop making the payment, I'm recording that quick claim deed.
That's a problem.
I mean, what?
call me. That's all I can say.
Oh, so what are the pros and cons of that?
Don't do it.
Okay, but why?
Because what's the purpose of that deed?
To eliminate the foreclosure.
No. What's the purpose of that deed?
Well, to secure the collateral, to secure the mortgage.
What do we call that? To secure the debt, right?
Right.
We call that a mortgage.
We call that a mortgage. That's what he has.
Right. But that quitclaim deed was executed at closing.
It was executed at closing simultaneously with the mortgage.
Right. I only know of one case in the state of Florida where that was supported.
How could you support that?
It was Barnum and Bailey.
Okay.
They were in
Circus?
foreclosure. I don't know, but it's Barnum and Bailey. Okay. Barnum Brothers or something like that.
Okay.
They were in foreclosure. The third mortgagee, who was getting ready to lose his position, coughs up the money to take out the other two mortgages. And they take that position and they do a refinance of some sort, but they get a deed in lieu of foreclosure
Up front.
up front. And there was lawyers on all the sides. It was negotiated up front, and it was to help an already that third
Rusty.
mortgagee was
That
actually
is
doing something. That is such a
such
unique. It's a very
an
unique.
exception.
Right. In fact, the appellate court said we're doing it here, but that is not an excuse for anywhere else.
Okay. So anybody who does that, what would you call them besides?
If they get away with it, fine. I don't
What do you
think
mean
I'd
they
want
get
to-
away with it.
If I would
Could you defend that?
defend what they're
Go
doing.
back to me and
it.
Ben. Okay, go back to me and Ben here. Ben says, I'll loan you the money, Steve, for $300,000, but you're going to give me a quitclaim deed.
I'm not representing Ben.
Comes time to foreclosure, I want representation. This guy recorded this quitclaim deed, and now he's evicting me. He went to a sheriff, and now
No,
giving me
wait a minute. He has to have an eviction case first. Probably unlawful detainer. Okay.
the property's his now.
Right.
So now he's going to the courts to get me
All
out
right. And you have
because
to-
he owns the property.
But you get service of process, right?
Yeah.
And you're not going to ignore the summons.
No.
Okay. Well, then you got plenty of time. The
Could
first
you
thing
defend? Could you defend me signing that
course.
quitclaim deed? What would you do? How would you defend that?
I would first thing would be out of county court in the circuit court.
Okay.
Okay.
And say,
And then
can't do that.
I would probably go on the offense, assuming we had the money to go on the offense to have that deed.
Oh, by the way, I don't have any money.
Well, then we may have to sell
kidding.
body parts.
I don't have 300,000 either
So
to lend you.
so I would probably have to. It would probably be better to go on the offense to have that deed voided.
Okay.
What if it's a enhanced life estate deed? Is that okay?
Well, you're gonna make the loan, and he's gonna give you a ladybird deed.
Only if he
If
dies.
he dies.
Yeah.
Oh, that's
Well,
actually
we can-
slick.
Okay, but you're still alive.
Yeah.
But what if I die? That's wow.
Got to think outside the box.
That's an,
That'd be
that's
like
an
a-
insurance
that'd be-
policy there, buddy.
That'd be like a will, though.
Wow. Hey, you're gonna loan me the money, and
Well,
if I die,
if it's homestead-
it's your property. Merger of title, mortgage goes poof.
That's
I
not,
like it.
judge probably would support that.
That would be different.
Yeah, all the heirs are coming back. That deed's
Yeah.
false.
Yeah, you might be.
That deed's
You may have a
fraudulent.
battle on your hands.
Yeah, but hey,
You couldn't give me a life insurance policy, so I took a life
I like
insurance.
Ben's idea. I'm gonna
A life
shoot, man,
insurance
that's
policy is the ladybird deed, except you can cancel it anytime you want.
I
Yeah, that's
That
true.
is true.
So what good? And you got to record it.
That's true.
So
All right, but back to the quitclaim deed. Can you'll defend that and make that deed? Make
I
that
will-
deed evaporate.
that deed should evaporate.
Not should. Will you win?
I have lost that case once.
How?
Don't know.
Dude, man, you're messing with me. How would you lose that case, Rusty?
I had a judge.
Not in St. Johns County.
No, in St. Johns County.
Okay.
When I walked out
So
of the trial,
again, the
I
only thing
knew
you
I
guarantee
won.
is death, divorce. I mean, death, taxes, and death. Right? That's only three
Yeah,
things.
death and
Death
taxes.
and
Yeah.
Okay.
No, death, taxes, and death. Those are-
Okay. But the
Double down.
it was like this. That judge was shaking his head the whole time. Like he was eating right out of my hands right
You
until
could appeal that and win.
I could. Didn't.
You probably should.
Until too late.
Well, that's
But
a
the
shame.
point is this.
Well, here's the other risk.
You can't do that.
First of all, every time a lender tells us to do that, we're like, man, we really can't do that. We can't be a party to that. We see it happen a lot. But here's the thing that people need to understand, that when you take that quitclaim deed and you record it, you are now subject. Your mortgage loses priority.
When you record it, there's a merger of title
Your mortgage loses priority.
to what?
Anything else that person might have done to the title, or anything that might have been filed against. that
Well,
person.
yeah, but they don't have any money anyway, so what's the big deal?
Rusty, remember our dude in Jacksonville that took a deed in lieu of foreclosure and found out that the guy had a $900,000 IRS lien against him?
He should have foreclosed.
He didn't.
Well,
So what did he want to do? Do you remember what he wanted to do?
I can't remember what he wanted to do.
Well, you brushed him off so quick, he just had to go, mental hospital afterwards. We're talking about a big loan.
Yeah.
This was.
I kind of remember.
I mean, I don't remember the numbers specifically, but this guy had lent probably $800,000, $700,000, and he decided, I will make this easy. The guy says, I can't pay. It was a bad decision. I'm so sorry. Everything's amicable. Here's a quitclaim deed in lieu of the foreclosure, so you don't have to foreclose. happy dappy.
Quick claim deed, warranty deed don't matter.
Doesn't matter. It's a quick claim deed.
The deed.
Warranty deed, just deed. Records a deed. He's happy dappy. I didn't have to foreclose. He gets the property up for sale. He's selling and making some money on the sale, and there's an IRS lien. So he panics.
So he didn't get a title search, huh?
No.
Well, not dumb.
If you take a deed in lieu, I'm going to tell this to everybody right now. You ever take a deed in lieu of foreclosure, you need a new title policy. You don't get a merger of title and a deed.
No, but that's when you prevailed. Now,
No.
I thought there was coverage for a deed in lieu of foreclosure as long as nothing intervened.
No. If you foreclose, the title policy you get as a lender turns into an owner's policy. If you get a deed in lieu of foreclosure, you must get a new title policy.
I'll check.
Okay.
I would think.
I've never been wrong. I've never been wrong
that you under
before.
that. I think you would know that.
So
but
why would you check me when I've always been right? Don't look now. Come on. We got.
He once thought he was wrong,
can't
but he
help
was
himself.
mistaken.
Yeah, there you go. Don't look it up now. I need you to focus with me, Mr. ADD man. Can't help himself. Just can't help himself. Listen, the point is this. You need not to take that quick claim deed without doing a search or getting a title policy because you're subject to everything that's transacted on that property. Right?
Oh, yeah.
Okay. This is why we can't have a radio show.
Why?
Because you're too easily distracted. Mr. Chat GTP.
Well, the magic box says no, a mortgagee title policy does not automatically turn into an owner's policy when a deed in lieu is accepted.
Ching.
There you go. It remains a loan policy.
You know what? And I should be happy when you take time to prove me right. So thank you.
I know the mortgage policy turns into an owner's policy on foreclosure. That's.
But in this case,
that's the whole purpose of it.
So you take a deed in lieu of foreclosure, you think this is great, right? It might not be. Because what if that person went out and got a second mortgage you didn't know about?
Well, then why would you not get a title search at least to figure out what happened?
Why
not
do
just
a
get title
lot of
insurance
things
be done? Okay, sure.
I mean, I don't have. Yeah, people think they're saving money. It's the easy way. If I have a mortgage and I take a deed in lieu, it should be in first position. It doesn't happen that way, and that's why I want to share with you.
Think about it.
Deed in lieu of foreclosure, get a title policy.
When you're in first position and you foreclose, who gets wiped out?
Any person or entity who has a position that's junior to your mortgage.
Is that the end of the sentence?
Oh, pretty much.
Well, you're wrong.
Well, then make me right.
What do you have to do to get rid of them?
Notice.
They have to get notice.
Right.
An opportunity.
I thought that was included. In my statement. That obviously.
I asked if that was a period at the end. And
There's
said
a
yes.
period, but
okay.
Yeah.
Okay. So now, if we didn't require that, what would be happening if you took a deed in lieu of foreclosure and the second mortgage disappeared?
Yeah. There's
no due process.
There's no due process.
How is that even right?
It's not right.
Okay. So it just follows.
But even if you did notify them, hey, I'm taking a deed in lieu of foreclosure. You cool with that? They're going to say, no, I'm not taking. I'll be in first position. I'll foreclose your butt out.
Remember what happens with a foreclosure. If you're in second position as a second mortgage,
Mm-hmm.
I'm in first position. So what happens at the sale? When a third party, if I'm not the high bidder as the first mortgage holder,
Mm-hmm.
what happens?
The second mortgage goes bye-bye.
It does, but what do they get in replace?
Surplus, if there's any.
There's surplus.
If there's surplus.
Right.
But they have to go get it. It doesn't automatically come to them.
Right.
Okay.
But everybody gets in line. Okay?
Everybody gets in line for the surplus, if there's surplus.
Well, but there'd probably be some equity there if there's a second mortgage.
You don't know.
You don't, but
No.
Why would a second mortgage get in that position?
Because some friend stepped in and said, hey, man, I'm going to be here to help you out.
Well,
it happens, dude. It just happens. Okay. But this has been Land Title Talk. We could talk.
Or the Collins boys arguing.
Yeah, that too. But we appreciate you listening. Again, we encourage you to text us with questions at 904-501-4481, 904-501-4481, or email us your questions at golly gee.
Email your questions at 90 what?
Email your questions at Stephen@golandtitle.com, STEPHEN @golandtitle.com. I'm Steve Collins from Land Title, and we've been writing title insurance in this beautiful town. Golly gee, as a family
Since 1979.
Since 1979.
And don't be afraid to ask a lawyer a question about some of this stuff. It doesn't have to cost a lot of money. And it may save you a lot of money.
On that point, we have Rusty who's been with us. Rusty, how do they find you?
904-829-6600, and hopefully Ben answers.
And hopefully Ben answers. All right, and you can find Ben there too. Ben's a great guy to talk to. He's very knowledgeable, Dr. Ben. And you can call at the 904-829-6600 and get Ben. You can also call us at 904-797-9600, 904-797-9600. This has been Land Title Talk. We appreciate you listening. We will see you next week.